So we're going to start with the introduction on interceptions of communications in IT law. So interceptions of communication in IT law is an important topic within the realm of information law. So in Zimbabwe, as other countries, technological advancements in the field of information technology has revolutionized the way people communicate and share information. So it is more efficient and accessible. It is also heightened concerns about the interceptions of communications and the potential of privacy violations. So many countries have enacted acts, legislation to regulate the interception of communication and strike a balance between protecting fundamental rights and ensuring law enforcement capabilities. So, with the advent of Information Technology Act in 2020, Zimbabwe has taken significant steps ensuring in creating a legal framework to regulate the interception in our country. So, moving on with the introduction, Zimbabwe has an Interception of Communication Act, chapter number 1120, which states that the Act provides for the lawful interception and monitoring of certain communications in the course of transmission through a telecommunication, postal, or other related service system in Zimbabwe, to provide for establishment of a monitoring center and to provide for other matters connected or incidental to the foregoing. So the statute has provisions of controlling interception. Section 3 of the Act recognizes that interception in communication in the course of transmission by means of telecommunication system or a radio communication system is unlawful if done without authority. However, this act was repealed by the Cyber and Data Protection Act of 2021. The Act provides for data protection with due regard to the Declaration of Rights under the Constitution, the public and national interest, to establish a cyber security center, a data protection authority, and also to provide for the functions. So to create a technology-driven business environment and encourage technological advancements and the use of technology, the Interception of Communications Law, chapter number 1120, has always been crucial. So the Interception of Communications Act is a clear intention which is to intercepting of personal, private, or such communications without limitation as to the form of the communication. It can be either in email, short messages, voice, video, print in the form of letters, telegraphs. So the Information Communication Act provides a limited number of individuals that are authorized to allow for a warrant of arrest. First of the concern is the fact that the warrants are issued on the ground of belief and not on a reasonable suspicion that a criminal offense is about to be committed or was committed. So the standard of test for insurance warrants that invade a person of artificial intelligence rights. So service providers must ensure that the equipment is able to facilitate interception of information, installation of software, hardware. They allow for the simultaneous interception. Also, the Act criminalizes the non-compliance and non-cooperative service providers. So Zimbabwe Internet Service Providers Association raised concern with this act, but there's no record indicating whether the members then objected to installation of intercepting software and involvement of administering and executing such warrants. So this act severely encroaches on communication rights of and freedoms that's unregulated surveillance, potentially undermining the implementation of a just and a fair internet government regime. So, the Constitution of Zimbabwe, section number 57, subsection D, states that every person has a right to privacy, which includes the right not for their privacy of their communications to be infringed. So it does not, however, provide in clear or in unequivocal terms a protection against being the subject of physical or other surveillance in the form of or must be read in the above protection. So the right to privacy is, however, not absolute and is subject to limitations clauses to the same constitution, which require, among the things, to exercise the right of privacy reasonably and with due regard to the rights and freedoms of other persons. The state and even other private institutions and other groups are also subject to citizens to all manner of invasion of privacy by way of either interception of communications or surveillance. In Zimbabwe, there exists a legal framework for the protection of privacy as well as the lawful invasion of privacy, investigation and prevention of criminal and civil wrongs in the rule of the Constitution of Zimbabwe. So moving on with our presentation, the Access to Information and Protection of Privacy Act protects personal privacy and personal information as it established that personal information for purposes of the Act and the protection thereof is defined to mean recorded information about an identifiable person. So the crucial matter in dealing with interception of communications is who has the authority in terms of the law to intercept communication, and what's the vesting the power, who vests the power to authorize the interception of communications. Is it the minister responsible for the administration of the act, or it is both undesirable and problem? So it is, however, not accepted because it flies in the face of the constitutional doctrine of separation of powers. It raises challenges since it creates a situation where the law enforcement agents, part of the executive arm government, apply to their superior within the executive branch to carry out an executive assignment. So judicial oversight regarding the constitutionality and other legality of the warrant is completely missing, as the executive is not charged with the interception of legal rights relative to executive administrative conduct. So the right to the protection of the law is completely neglected by this arrangement and is only left in the tail end and where possible the administrative court of Zimbabwe way was damaged and has already been. So it remains a debate issue who should, according to the law, have the authority on interception of communication, which doesn't violate human rights or the constitutional prevention against private rights, freedom of association, and the likes. So we have an example of a court case, that is the case of Ministers of Law Society of Zimbabwe versus Minister of Transport and Communications, in which the Supreme Court considered the constitutionality sections of the Postal and Telecommunications Act, chapter number 20.05. The sections considered were similar to those of the bill and empowered the President to direct that communications should be monitored if, in his opinion, it was necessary to do so in the interest of national security, public security, or maintenance of law and order. He was also empowered, after consultation with the responsible minister, to give service providers such directions as he considered to be necessary in the interest of national security or relations with foreign states. So the Law Society challenged these provisions on the ground that they afforded no protection to legal practitioner and client privilege. This Supreme Court found them to be unconstitutional in the judgment said. So, concluding my discussion, there are many concerns expressed by the constitutionality of the bill regarding the interceptions of communication. Freedom of expression is guaranteed by the Constitution in Section 20, subsection 1, which reads as follows: except this is an on consent or by way of parental discipline, no child shall be hampered in the enjoyment of his freedom. Also, in the case of correspondence, preventing the unlawful dispatch, therefore, of any matter. However, any restriction will be invalid if it is demonstrated that is not reasonably justifiable. So, the case of interception of communications have been a debate throughout since it was installed. So, we still need to develop it and see who is liable or who has the duty to intercept communications and what degree do they have in terms of lawyer-client privilege, private interest, and the likes. Thank you.